Good morning, everyone. I am just waiting for people to join in. I can see the participants here, and lots of people are just joining in. Good morning to everyone who's joining. That number's rapidly going. Good morning to everyone who's joining. I'm just waiting for everyone to join in. And once that number's stopped ticking up, we'll get started. Okay, people still joining, so we'll just hold on a moment while others join.
A bit like doing popcorn in the microwave, isn't it?
Absolutely. The watched pot never boils. Okay, I think we're nearly there. A couple more just coming in. I'll just give that till 9:32. Good morning, everyone who's joining. I'm just going to wait a moment just for a couple more to join. Right, so our participants are fairly stable now. So, good morning, everyone, and welcome to this Restructuring and Insolvency webinar on behalf of St Philip's Chambers. My name's Mark Brown. I'm head of the Restructuring and Insolvency team here at St Philip's Chambers. I'm joined by Ali Tabari, barrister and mediator and member of the Restructuring and Insolvency team. So this morning we're going to talk to you about the Corporate Insolvency and Governance Bill. I'm going to talk about the permanent changes that the bill proposes to bring in, and then Ali's going to talk to you about the temporary measures that the bill introduces as a result of and during the coronavirus pandemic. Just in terms of some housekeeping and technical issues, at the bottom of your page you should see a Q&A button, and if during the webinar you would like to ask us any questions, please do put your question in that box, and then at the end of the presentations we'll go through some of those questions, hopefully answer them for you. And in a moment, what you're going to see is I'm going to be relegated to a small box in the corner of your screen, and a slideshow presentation is going to come up that will take you through our talk today. So, without further ado, I'll start talking about the permanent measures. Just bear with me a moment, and I will share the screen with you, and you should see now the slideshow presentation for today. So, starting with myself, the permanent measures introduced by the bill. There are three significant permanent measures. Some of these may be familiar to you because they were the subject of a white paper and consultation introduced well prior to the coronavirus pandemic. And there was the opportunity for significant stakeholders to contribute by way of the consultation paper to the development of the ideas. Now, it was somewhat of a surprise that they were then introduced in this bill as part of the coronavirus pandemic measures. One may query, if it were not for the pandemic, would these have been introduced in the form or at the time that they were? or have they been introduced because they were on the shelf and practically ready and suggested that the government had a response for business to the pandemic, i.e. was it somewhat opportunistic to bring these in at this time? Nonetheless, they are shortly to become law. There are three significant developments. The first is the company moratorium. The second is the cross-class cram-down. That's been titled as the Restructuring Plan. The term cross-class cram-down has come from the US, from Chapter 11 bankruptcy proceedings. And during the stages of the white paper, we had sought to develop an acronym for the cross-class cram-down. And CCCD is quite a mouthful. It doesn't really work. I think the best that we had come up with was CCCD. But in fact, now that it's been titled in the bill, the Restructuring Plan, which incorporates the cross-class cram-down, I think we're unlikely actually to use that phrase. And what we'll actually see is us just using the phrase Restructuring Plan, or RP. The third is the termination clauses and how we're dealing with those as a result of insolvency. So I'll start by dealing with the company moratorium. So this is a new insolvency procedure, as indeed is the restructuring plan. And eligible companies can obtain a moratorium giving protection from their creditors. So what's an eligible company for the moratorium? That's dealt with in Schedule ZA1 of the bill. Certain companies are excluded from access to the moratorium, for example, financial services, banks and insurance companies and otherwise. But generally, companies will be eligible for the moratorium unless there is already a moratorium in place in respect of them, or they've entered into a moratorium in the 12 months before they now propose to enter into one, or if they're subject to an insolvency procedure, or they've been the subject of any insolvency procedure in the 12 months before. Now, what those indicate to us is that the moratorium is really meant for companies who are at the start of their troubled existence. They haven't previously been through a process, they're not currently going through a process, perhaps they're not yet at the stage where they might consider a more formal process like administration, like liquidation even, or a CVA, but you can see they're heading in that direction. And that really looks to be what the moratorium is aimed at, along with if they might be entering into one of those other procedures and need a bit of time to work out what the right procedure is. How do you obtain the moratorium? Well, if the company is not overseas or already subject to a winding up petition, all the directors need do is file the relevant documents at court, and they will then enter into the moratorium. Slightly more complicated if the company is already the subject of a winding up petition, or if it's an overseas company. In that circumstance, there's going to need to be an application to court to enter into the moratorium. If an application's made, the order will be made if the court's satisfied that the moratorium would achieve a better result for creditors as a whole than would be likely if the company was wound up without first being subject to a moratorium. And I've mentioned the relevant documents that will need to be filed by the directors, and these need to be filed if an application is made as well. These include, importantly, a statement from the directors that the company is or is likely to become unable to pay its debts. So we really are looking at prospective or actual insolvency for the moratorium to be appropriate. Those documents also include a statement from somebody called the proposed monitor that the company is eligible, and that it's likely that the moratorium would result in the rescue of the company as a going concern. So who's the proposed monitor? Well, the proposed monitor is an insolvency practitioner. And you'll note from this that the directors will have selected or had an eye in selecting the proposed monitor. Now, if we compare that for a moment with administration, in administration, of course, the directors may seek an administration order and might well approach an insolvency practitioner for the purposes of selecting their proposed individual. A qualifying floating charge holder will be given notice of the application and can use its powers to appoint its own insolvency practitioner. That thereby gives, in administration, the secure creditor, the qualifying floating charge holder, some control or some say over the proposed insolvency practitioner if they wish to. Now, in respect of the moratorium, there is no ability on the part of the qualifying floating charge holder or otherwise to step in and take control of the identity of the proposed monitor. That remains the sole prerogative of the company and the directors. So secured creditors and qualifying floating charge holders do not have as much control over the moratorium process than they might have over the administration process. How long does it have effect? Well, the starting point is 20 business days. That can be extended by the directors in various different circumstances, either depending on whether they have or do not have creditor consent for that. It can be extended by the court on application, and it gets extended while a proposal for a CVA is pending or other proceedings. And then it can be terminated upon entry into another procedure. It can be terminated by the monitor if the monitor doesn't believe the conditions satisfied any longer, or it can be terminated by the court. You'll note immediately that 20 business days is not a significant period for a company to enter an insolvency procedure. What's the general effect of the moratorium? Well, it introduces a restriction on enforcement and on payment of pre-moratorium debts, subject to some exclusions in respect of, for instance, the monitor's fees. So what it effectively gives rise to is a payment holiday for a short period for the company. And given how short the period is and that it is effectively just a payment holiday rather than any sort of compromise with creditors, it seems to me that the moratorium as a standalone procedure is unlikely to have the effect of giving rise to a better result to creditors or rescuing the company. It seems to me that the moratorium is more likely to be a stepping stone along the way to rescuing the company. It gives a breathing space, and in fact that's the phrase that was used in the white paper, although it doesn't appear in the bill. It gives a short period for the company to be free of creditor pressure, to examine its options, to engage with creditors and other professionals to see what the appropriate route out is for the company. That might be obtaining further funding. It might be a sale of part of the business. It might be administration. It might be a CVA, or it might be a restructuring plan. So in my view, the use of the moratorium is a stepping stone. It's a breathing space. Time for the company to assess its options, take the appropriate professional advice, and see what the best route out is for the company and for its creditors. The monitor that I've already referred to, as I say, is a licensed insolvency practitioner. It's expressly provided that the monitor is an officer of the court. And the purpose of the monitor is to monitor the company's affairs for the purpose of forming a view as to whether it remains likely that the moratorium will result in the rescue of the company as a going concern. The company remains in the control of the directors, and so the monitor provides some oversight to ensure that what's being done is not making the situation worse for creditors as a whole, and is doing something to progress towards how the company is going to proceed afterwards. And with the ability for the monitor to either apply to court or to terminate the moratorium if that's no longer happening. And the monitor has the opportunity to apply to the court for directions, although one would imagine that any directions that the monitor is going to seek are going to be quite urgent matters, given that it's going to need to be heard within that initial 20 days or extended for it to be any use. So one would imagine that the monitor is only going to really seek directions either as to the appropriate course forward, or decisions that would affect the course going forward, or very urgent matters. There's also provision in the bill for challenges to be made to the moratorium. A creditor, a director, a member, or any other person who's affected by the moratorium can apply on the ground that an act, omission, or decision of the monitor or the directors has unfairly harmed the interests of the applicant. One would expect those sorts of challenges to be governed by the same sorts of principles that govern IVAs and CVAs, where there is an unfair harm challenge available. So that's the moratorium, and I'll deal secondly with the restructuring plan that incorporates the cross-class cram down. This is another new procedure. It's in addition to other mechanisms for compromising with creditors, and it operates in much the same way as a scheme of arrangement. However, schemes of arrangement have generally been for very large and complex restructuring processes, and the idea here is that the restructuring plan will bridge the gap between CVAs for smaller companies, schemes for large restructuring projects, and that the restructuring plan will span the two and bring the benefits of both to companies of different sizes. Like a scheme, but unlike a CVA, the restructuring plan can affect the rights of secured creditors, and it can do so without their consent. But unlike a scheme, it can be sanctioned by the court, even if not all classes of creditors vote for it. And that's subject to some criteria, most importantly, that as long as the class of creditors who are being affected, even though they didn't vote for it, are no worse off under the plan than they would be otherwise. Now, I have been asked a couple of questions in advance of this webinar about the restructuring plan in particular. It's interesting to see that that's where our questions are coming from at the moment. And it's most useful if I answer those now to give you an idea about the restructuring plan. Firstly, DLA have asked, will the restructuring plan be a game changer that ousts administrations, or will the costs of a restructuring plan be prohibitive? And in fact, they'll only be used for large-scale restructuring, similar to schemes. Well, my answer to that is I don't think that restructuring plans are going to overtake administrations. Administrations remain the most flexible way of dealing with restructuring of various different sizes of companies. And I think the restructuring plan is a slightly different route. I actually think it's going to be quite a targeted response. It's going to be an insolvency procedure that's used in really quite specific situations where the circumstances of the company create very different interests of different creditors. And you have in particular creditors who are interested in the long-term success of the company retaining its assets for the benefit of its business and its success long term, as opposed to the interests of creditors, say short term, who a sale of the assets would result in a payment to them immediately. And therefore you have classes of creditors with different interests in the company and therefore different interests in the liquidation. And this allows the court sanctioning the restructuring plan to take a view as to what's in the best interests of everybody altogether, rather than those classes of creditors having a particular interest in their own position. Secondly, I've been asked by shoesmiths about a comparison of the restructuring plan with a CVA. And can I consider a scenario where the restructuring plan would be more advantageous than a CVA, other than one in which creditors vote to cram down the secured creditor? Well, my answer to that is that the cram down doesn't just necessarily involve the secured creditor. It's really any situation where a class of creditor, whether that be the secured creditors, perhaps contingent creditors, where they're going to vote against the CVA, but in fact, the restructuring plan, but in fact, the plan is in the best interests of the company as a whole. A scenario that one could imagine is one where a class of creditor is going to receive nothing in a liquidation, and they're going to receive nothing in the restructuring plan. So they're really no better off and no worse off, whether under the restructuring plan or in the liquidation. So there's no incentive on that class of creditor to agree to the restructuring plan. And on that basis, they might vote against it. In fact, they might vote against it to obtain an advantage to which they are otherwise not entitled, so as to encourage their approval of the restructuring plan. And in fact, the department refers to that as a specific example of where the restructuring plan might be useful, particularly if those creditors have sold their interests to others, referred to by the department as predatory actors, those who might acquire nil rights for the benefit of extracting a benefit to which those rights might not otherwise be entitled. What I'm going to do to try and demonstrate this is share with you, or try and share with you, here we are. So you should now be seeing an extract from the Department of Business, Energy and Industrial Strategy, where it talks about guidance on the restructuring plan. And we have an example of how one class can block a scheme that other classes support. Here we've got three classes of creditors. We've got a class A with 100 million of debt. In liquidation receives 100 million, but actually it's proposed as part of the restructuring plan that some of their debt will be reduced. 95 million will be proposed in the scheme, and that's a better result, or that goes down to class C of creditors who have a debt of 20 million, would receive 2 million in the liquidation, but receive 7 million in the restructuring plan or in the scheme, and that's come down from class A. So class A agrees to that because it's interested in the long-term survival of the company. Class C agrees to that because their prospects are better in the scheme than they would be in the liquidation. Class B, on the other hand, has debt of 100 million and in liquidation would receive 48 million and would receive that same 48 million in the event of the scheme. So they're no better off, no worse off under the scheme. And because of that, they're against it. Well, we can see here that one could take the view that this is in the best interests of creditors as a whole. Class B of creditors are no worse off, and so their rejection of the plan should be overridden. And one can see here again the creditor class very similar in the restructuring plan. The for and against, and under the restructuring plan the court can override the views of the class B creditors because they're no worse off and it's actually in the best interest of creditors. So we'll just go back to the slideshow, and that's the restructuring plan. So as I say, I think it's going to be quite a targeted insolvency process where there are creditors with different and separate interests in the outcome. And actually the restructuring plan is going to have two purposes. One is to overcome and bind secure creditors. Two is to overcome a nil return creditor, or a creditor who's no worse off or no better off, and for that reason might vote against. Finally, the bill proposes to introduce a disapplication of termination clauses. So clauses in a supply of goods or services contract to which the company is a party, whereby the supplier can terminate the contract or do something else, for instance, change payment terms as a result of insolvency. They're disapplied and they're void. It includes not just the termination, but it also includes changes to payment terms. So it's specifically provided that the supplier cannot make it a condition of further supply that outstanding balances are paid. So the supplier can't say, you've got to pay me everything I'm owed up to now before I'll supply you anything further. The supplier is obliged to continue with the contract. But subject to some minor exceptions, generally suppliers will need to continue to supply to an insolvent company, even if they're owed significant sums from pre-insolvency contracts. That protection already applies to essential supplies, for example, utilities and IT. And really this is extending that to all contracts for the supply of goods and services. It applies across insolvency procedures, including the new moratorium, including the new restructuring plan, as well as existing procedures, administration and liquidation. There is a very minor carve-out, a temporary non-application to small entities that applies either until the end of June or 1 month after the coming into force of the bill. End of June doesn't really matter anymore, given that it's not passed yet and we're at the start of June. So 1 month after the coming into force of the bill. There's the possibility of extension to that. and we'll wait and see if that becomes a more permanent extension, or really whether this is supposed to apply across the board. What this is really geared towards is enabling companies either to continue to trade or to be sold as a going concern with the benefit of their supply contracts. It's possible that we might see more trading administrations as a result of the termination clauses no longer having effect. And it's certainly going to push towards the rescue culture. And as I've said previously when talking about the white paper, this really builds on the developments of the Enterprise Act 2002, the idea of the rescue culture. In the Enterprise Act reforms, administration was reformed so as to bring forward insolvency procedures through the administration route, looking to a rescue of the company as a going concern. It seems to me that the moratorium adds a yet further layer, going further forward or backwards, depending on how you look at it, from the end result of liquidation. It goes even further. The moratorium is yet further back to try and assist companies even earlier to see if they can be rescued. And the termination clauses provision and the restructuring plan, both, it seems to me, are geared towards seeking to rescue, if at all possible, and trying to avoid liquidation. So, I'm now going to hand over to Ali Tabari, who's going to talk to you about the temporary provisions in the bill.
Well, hello everyone, good morning, and I noticed that there's been a few questions on the Q&A, so while I'm saying my piece for the next 20 odd minutes, it might be that Mark has the opportunity to have a look at a few of those questions, maybe come back to you at the end. I'm going to try sharing my screen with you, and hopefully this is going to work as it should. There we are. Hopefully you will see there that I'm going to be talking to you about the temporary measures which are going to be put into place with the bill. And we're going to be dealing with three main parts: statutory demands and winding up petitions, the much fabled suspension of wrongful trading, and then a very short piece at the end about companies' house requirements and the likely changes to those as well. So let's start with statutory demands and winding up petitions. I'm not going to lie, this bit is quite fiddly. There's plenty of different provisions for different scenarios. And to be honest, there are enough holes in there, in my opinion, that it's probably likely to change a little bit between now and the time that it comes into force. But as much as anything else, it's probably worth highlighting the potential problem areas which might arise here. And the first of the problem areas, if we look on the slide, is what the relevant period is. There's lots of reference within Schedule 10 of the bill to the relevant period. Generally, we can take it as being from the 1st of June, from the 1st of March until the 30th of June. But a couple of things. One is that at other parts of Schedule 10, the relevant period starts on the 27th of April, not the 1st of March. And the other point is that the 30th of June date is likely to change. That's probably going to end up being 1 month after the Final Form Act comes into force. So I hope that's about as clear to you as it is to me at the moment. But as I say, when we talk about relevant period throughout this section of the talk, we're going to be talking about that 1st of March to the 30th of June period. And in the form that it currently is, the Act hopes that this will be coming into force retrospectively as of the 27th of April, and we'll see the potential problems that might come about where it seems that that ship has already sailed. So starting with the basic position, you'll have probably seen quite a lot of chatter online about it, and the basic position is that there's no winding up on a creditor's petition if it's based on a statutory demand which was served during that relevant period from the 1st of March onwards, and if a winding up order is made on or after the 27th of April. So any creditor's winding up petition based on a stat demand that fulfills those criteria is no longer valid. Now you might be asking yourself, What about if that's already happened? We will come on to that. Because there are two main deviations from that basic position. Now, the first deviation is this. We know that there's no compulsory winding up orders to be made on or after the 27th of April if it's based on a stat demand or an unsatisfied judgment, unless, and here comes the deviation, unless either of these two applies. And we're going to call these, for the purposes of the talk today, the exceptions. So the exceptions are these. Firstly, that COVID-19 has not had a financial effect on the company. Or secondly, that the facts giving rise to the winding up petition would have arisen even if COVID-19 had not had a financial effect on the company. Now, you can see very broad wording on the first of those exceptions. Pretty much every business in the country is going to be able to make out that there has been a financial effect on it as a result of the coronavirus pandemic. You'll notice in the current wording, there's nothing to suggest that it has to be a material financial effect or it has to be a substantial financial effect. It simply has to be an effect. And it makes me wonder what the point is, quite frankly, of this provision, because it's going to be virtually impossible for any creditor to defeat that part of the test. So it's more about the second part of the test, which of course is an alternative. Whether the facts giving rise to the winding up petition would have arisen even if coronavirus hadn't had that financial effect. And of course, we're talking about companies which were already unable to pay their debts, already circling the plug hole, and coronavirus really was the final straw as far as that company's solvency was concerned. I have an example in a case that I'm doing at the moment. We had judgment handed down in April, a substantial sum against the company, and when we've moved to post-judgment enforcement, before any hint of these regulations came about, they were saying, well, we're potless anyway. You think, well, all right, well, fine. If we've stat demanded them or if we've got an unsatisfied judgment as a result of winning at trial but not getting our money, well, then the evidence that they gave post-judgment for the enforcement proceedings is terrific as far as we're concerned for the second limb of this test. But you're probably not going to get too many occasions where it's so clear. So that's the first deviation. That's likely to be the main strand of any argument for a contested petition under these circumstances. The second deviation, is this. If a winding up petition is presented between the 27th of April and the date on which the final form act is passed, then if the exceptions weren't met, the court may make such order as appropriate to restore the position as would have been pre-petition. And if it's already made its way to the official receiver, then the official receiver must refer that matter to the court. Now, this one is, again, particularly vague. It's simply the presentation of a petition. It doesn't require an order to be made on that petition. It doesn't necessarily need to involve a statutory demand. It's just talking about any petition, full stop. And then, of course, we have the discretionary aspects, which we'll see the first of the subpoints there. The court may make such order as appropriate. Now, of course, there is an implication for a company if there's a petition that's been improperly presented and just hangs around undealt with. It adds to the risk of the company, potentially void dispositions and so on. And it might be that the court is asked to do something about the very existence of that petition even before it's been determined. But this is really, in my view, about as vague as it gets. The courts are finding it hard enough to deal with live cases, let alone people applying urgently to make such order as the court thinks appropriate about a petition that's been presented but hasn't yet been dealt with. So when I said at the start of this section that there might end up being changes between the current version of the bill and the final form, this is exactly the kind of lack of clarity that we are talking about. Now we go on to talking about where the horse has bolted. What if an order's already been made between the 27th of April and the date of the act coming in force? One would imagine that if you had a winding up petition listed tomorrow, the court would probably want to adjourn it off until the final form act is approved, because you don't want to just be creating work later down the line for everyone. But what if we're in a position where, say on the 30th of April or somewhere along those lines, a winding up order was made? What about that? Well, the regulations do deal with those. They say that if an order was made in that time, then it will be void. The order will be void if the exceptions were not met, and the court will give appropriate directions to the liquidator or the OR to restore the company to the pre-petition position. So going back even further than the order, it goes back pre-petition. And you'll notice that the wording here is proposed to be stronger. It's a mandatory reversal of the winding up. So again, though, you can see the first of those subpoints, it will be void if the exceptions were not met. So if you've already got an order that's been made, then if you're the creditor and you wish that liquidation to remain in place, then the argument there is to say, well, if we'd presented it then, and we'd gone through the exceptions as they then stood, would we have been able to get the petition home? And that really depends on the individual facts of the case, of course. But that highlights the likely area for future arguments to be had. Moving on then to the major changes to the insolvency rules that are being proposed. In respect of a post-27th of April petition, the proposed rules say that there is no advertisement required, and no inspection of the court file to be permitted until the court determines whether it's likely that the court will make an order on the winding up petition. Now, there's an obvious reason why, if it turns out that a petition isn't going to be upheld, that it shouldn't be advertised, it shouldn't lead to all the consequences of advertisement. An inspection of the court file, of course, it doesn't allow your trade competitors and so on, or suppliers or anyone like that, to be able to look on the file and say, well, there was a petition that existed at some point, it's obviously gone away now. So that's not going to happen. You can see the sense in that. But then again, here we are, until the court determines whether it's likely that the court will make an order on the winding up petition. It's a bit like a permission to appeal test. Is it likely that the petition is going to be found to have fulfilled the exceptions? You're talking about it almost like a two-stage removed test. And again, a likely area of arguments going forward is to be saying, well, if we've got this petition, is it now going to be a two-stage process? Almost like you have to have a filtering process to begin with, where a court has to establish whether or not in the first instance it's likely that it will end up making an order, and that necessarily means that one of the two exceptions is going to be met at the hearing of the petition. So having a one-time petition hearing where you all go and you deal with it first time around, nobody turns up, probably less likely now. It might be that it's a two-stage process. It's probably going to clog up the courts a bit more, and it might disincentivize bringing petitions in any event during that period. And of course, you'll see that the second proposed change there is that the petitioner must state on the petition that it considers that the exceptions are met. One would suspect that if you have a slightly unscrupulous petitioner who makes that statement on the petition without believing it to be true, there are likely to be some pretty serious consequences, at the very least in relation to costs. But bear in mind that that's likely to be an additional requirement of the rules. So that's it in terms of stat demands and winding up petitions. As I say, that expect some changes, but expect there to be a slightly different test for everyone to have to address. You might find that actually just going down a different road altogether is probably the more sensible option at this stage. As I say, courts are clogged up at the moment. The lists are very much in arrears. And by the time you come to have this argument, you might find that things have significantly moved on. I can see some questions which are coming through already. I think probably what I'll do, if that's okay, is I'll deal with them after Mark's had a chance to deal with his at the end, so I can scribble down a few thoughts for you. But keep them coming as and when. Now we're going to move on to talk briefly about wrongful trading. Nobody could have missed Alok Sharma having his day in the sun on the podium in front of the country's cameras, telling us very proudly that in order to try and ensure that business keeps on going as normally as possible, wrongful trading is going to end up being suspended for a period. Politically, it's pretty good. When you look at it in a bit more detail, I'm not sure that it's going to be really of any practical use, and I'll spend a few minutes discussing why that is. This is the proposed text on wrongful trading. It says that in determining for the purposes of the wrongful trading provision, the contribution, if any, to a company's assets that it's proper for a person to make, the court is to assume that the person is not responsible for any worsening of the financial position of the company or its creditors that occurs during the relevant period. And of course, the first thing that I think the eagle-eyed black letter lawyers here will spot is that there's no suggestion elsewhere in the text that this is an assumption which can be rebutted. It seems to be very much an absolute. I'm not quite sure how that's going to work, but if we go on just briefly to say that this wrongful trading suspension doesn't apply to directors of companies which are banks and building societies, the same list that Mark gave you earlier about companies that aren't eligible for a moratorium. If we put those to one side, it actually doesn't affect anything to do with the director's ongoing duties and liability under those duties in all of the things that you can see on the screen at the moment. If we just think about the statutory duties that directors are under the Companies Act, nothing in Alok Sharma's announcement about wrongful trading affects the ongoing nature of those duties, and it doesn't touch the BTI and Sequana latest guidance. Of course, you will have seen all of that at the back end of last year, where the guidance from the higher courts was that the point at which creditors' interests become paramount is where the director knows or should know the company is or likely to become insolvent. Well, if you're the kind of company which is likely to be needing to rely as a director on the wrongful trading suspension, you're probably a director of a company where you know or ought to know that the company is or likely to become insolvent. So on the one hand, you've got nothing in relation to, you've got nothing in liability in relation to the wrongful trading, and yet at the same time under section 172, there's nothing to say that anything changes. And so a misfeasance action can be brought against you. You've still got the existing provisions on fraudulent trading, TUVs, preferences, section 423s, all of those continue to apply. And so if you think about the level of contribution that any judge might ask a director to make in relation to breaches of Companies Act duties or under fraudulent trading or something like that, it's the same figure as you would expect to be levied on a director if they were guilty of wrongful trading. So it might simply be that this suspension period for wrongful trading means that if you were thinking about that action in this period, probably not worthwhile. Is it worth giving up the ghost for all of the losses that the company suffered during the relevant period? Well, no, because you could probably still recover those by other means, as you can see on the screen. Now, it might well be that in the future, if that happens at trial, then the director may be able to say, well, hang on a second, wasn't the whole intention of the wrongful trading suspension that we wouldn't be liable under that provision or any other? It doesn't make sense for there to be inconsistent parts of the Insolvency Act scheme to say that you're not liable for wrongful trading for this period, but you can still be liable for basically the same losses in some other period. We'll have to wait and see. As with all of these things, it will take a good few years for all of that to be flushed out. Finally, and probably the quickest part of this talk, Companies House requirements. Again, just to flag these up, these are perhaps the most helpful part of the bits which I'm discussing today. Gives a bit more latitude for some of the formalities for companies. So some of the examples that are being proposed, I don't suspect there's going to be too much change between now and final form. Meetings due between the 25th of March and 30th of September. So you'll notice that the government's expecting the coronavirus tail to be quite a long one. Those meetings can be held remotely. Voting can be done by any proper means. AGMs can be held up to 8 months after the appointed time, to be determined by the Secretary of State or the Treasury, depending on what type of company you are. Just a point to mention there about to be determined by the Secretary of State and so on. Within the bill, there's a whole section at the end which says that the Secretary of State can make regulations from time to time all the way up until April 21. That is, I think, a good and a bad thing. It's good because it can be quite responsive, it can be quick and flexible, and if things don't work, then they can be tweaked as we go along. For those of you wondering whether you can mix with 2 people or 6 people or 5 people and different combinations outside and what's necessary, you'll have noticed that at the weekend there's a whole bunch of other regulations which came in, which gave the general public 14 hours notice of a potential new criminal liability about to be imposed on them. So the good and the bad side of regulation making is all there. And if we go on to the final slide there, other requirements for Companies House are being relaxed. There's extensions of time to file accounts which are due after the 25th of March, and that's likely to be up to about a 6-month extension. And in terms of notifying Companies House of certain listed changes, there's a whole definitive list of them at the back of the bill. Again, there's going to be extensions of time. So where there are 3 or 6 or 9-month limits, those are going to be extended to 12 months. Where there are 21-day limits, for example, registration of charges, those are going to be extended to 42 days. I have put as a small point to maybe think about whether or not there will be an effect on future office holders of unregistered charges which haven't been registered within 21 days as you'd expect. But in reality, the difference between 21 and 42 days is so small that in the end, it's going to be very rare that it makes any practical difference. So I hope that's been a helpful run through. What I'm going to do now is I'm going to stop sharing the screen. And I will hand back to Mark to perhaps deal with some of the Q&A. And while he's doing that, I'll look at some of the questions which have come through. Thank you very much.
That's great. Thank you very much, Ali. And there's some very useful questions, some for me and some for Ali. And we'll have a look at those now. So first, I'm asked in relation to the moratorium that we discussed earlier, the differences between the filing of the relevant documents where there's no winding up petition and an application where there is an outstanding winding up petition. There is indeed a difference in the drafting between the tests that are to be applied. What the monitor's got to do is say that the monitor believes that the moratorium will result in a rescue of the company as a going concern. So not a better realisation for creditors, not a distribution to secure creditors, the other 2 parts of the 3-part test we're familiar with for administration. But what the bill actually says in relation to an application is that the test to be applied by the court is whether the court's satisfied that the moratorium for the company would achieve a better result for creditors as a whole than would be likely if the company were wound up. Now that's odd because that's a different test to the one which the monitor is applying. Now that could be that there's a mistake in the drafting there, that in fact what's intended to be applied is a test across the board of a better realisation for creditors. In fact, it could be a mistake that what it should have said is that the court is satisfied that the company will be rescued as a going concern. Or alternatively, perhaps that's the way it was meant to be, that the monitor is the best person rather than the court to decide whether the company is likely to be rescued as a going concern. And all the court is able to do is determine the lower level of whether the moratorium is likely to result in a better result for creditors, with the additional fact of the monitor saying that he or she thinks that the company is likely to be rescued as a going concern. So we'll see whether that gets amended as the bill progresses, whether it was in fact a drafting mistake, and if so, whether it gets picked up on its way through, or whether actually there's intended to be that different test that the court's applying on application from what the monitor is supposed to be verifying. Secondly, I'm asked what's the extent of the monitoring obligations for the insolvency practitioner? What's the potential penalties for failing to do so? Well, the obligation of the monitor is to form a view as to whether it remains likely that the moratorium will result in the rescue of the company. The IP is entitled, expressly provided in the bill, to rely upon information provided by the company unless he or she has reason to doubt its accuracy. And the monitor has powers to require information to be provided by the company for that purpose. What are the potential penalties? Well, what can the monitor do? The monitor can apply for directions if the monitor is not able to obtain information or doesn't know whether to rely upon it. The monitor always has the opportunity to terminate the moratorium if the monitor doesn't believe they're getting the right information by the company. And then I referred to the challenges. That's really the penalty on the monitor is the challenge that can be made by a creditor, director, member to decisions of the monitor. And remembering that we're in a very short-term insolvency process in the moratorium, so it's not going to involve trading by the monitor because the company remains in the hands of the directors. So the monitor's obligation and job is much more limited. It's one of oversight to decide whether or not the moratorium should continue, and those decisions can be the subject of challenge by directors, creditors, or anybody else affected by the moratorium. The next question is, could a monitor be appointed as a subsequent administrator under the no prior professional relationship requirement? That one I can't give a definitive answer on because it depends on more on administrators or insolvency practitioners' conduct and how they view their own conduct and professional obligations. One could see significant advantage, for example, in the same way that an administrator going on to be a liquidator can be an advantage in terms of saving costs in getting up to speed with what the company has been doing. But there's also perhaps an advantage to a fresh pair of eyes. Of course, if the company went into administration and there was a qualifying floating charge holder, the qualifying floating charge holder won't have had a say over the identity of the insolvency practitioner when the company entered the moratorium. But then its rights to have a say over the identity of the IP will kick in when the company moves towards administration. So I'm sorry I can't give a definitive answer on that one, although I think it's likely that insolvency practitioners will be assisted by their regulatory bodies and a consistent approach will be taken in that regard. In relation to termination clauses, the question is, would the company's remedy be a mandatory injunction against a reluctant supplier? Well, the ordinary contractual rights would apply. So yes, a mandatory injunction is one way of dealing with a situation where a reluctant supplier is proposing not to supply or to change the terms of the supply, and the order would be to require the supplier to continue to supply on the terms of the contract. Whether that's an appropriate response probably depends upon how critical the supply is to the company. The more critical it is, the more likely that's going to be an appropriate response. And I say that because does it really breed good relations between the company in distress and the supplier who's on the hook already for a significant debt to then be enforcing further supply and further debt by way of court-mandated injunction? That may not be the best way of working together with creditors. But if the supply is so critical that it's required, in fact, that may be the appropriate response. I think the last one for me, before I hand back to Ali, is who decides on the characterization of classes of creditors for the restructuring plan? Can you have short-term and long-term creditors in different classes, even if they're both unsecured? That's a great question, because you'll have noted from my description of the restructuring plan that how you categorize classes is absolutely key, and that's how you can get past the class of creditors that doesn't see the restructuring plan as a benefit to it. The answer is this: it's the company that puts together the restructuring plan. So it's the company initially that decides which creditors will go into which class. However, the company doesn't have free rein in doing that. Firstly, that once it's developed the restructuring plan and put creditors into those classes, the company then has to apply to the court for an order convening the meeting of creditors or classes of creditors for the purposes of their voting upon the restructuring plan. So at that stage, the company is going to have to satisfy the court, even to get the order convening the meeting, that it has properly categorized the classes of creditors and not sought to obtain an artificial advantage by so doing. Secondly, once the meeting's been convened pursuant to that order, the meeting takes place. If any creditor at that stage believes they've been wrongly categorised, they'll no doubt make that plain when they decide in relation to the restructuring plan. And then the plan's going to come back before the court for the sanction of it. And when the court exercises its discretion to decide whether or not to sanction the plan, of course, if creditors have made clear their view that they have been wrongly categorised, that the classes of creditors have been wrongly drawn, then that, in my view, is going to be something that weighs heavily on the court's decision as to whether or not to sanction the restructuring plan. So I hope that answers the questions in respect of my part of the presentation. I'm going to stay on the video, and Ali hopefully has had an opportunity to have a look through questions to him. It seems fairly balanced. Ali, over to you.
Thank you very much. I've had a few questions, and I think I'll take them in a slightly different order in which they came. The answers are generally pretty short. One of the questions that has come through is whether or not, let me just see if I can find it. It says, if a winding up order has been made and is subsequently void, can the debtor argue that it should be entitled to damages from the petitioning creditor to compensate any losses arising? In my view, the very likely answer is probably not. At all stages, if a company owes money, then presenting a winding up petition will have been, up until the enforcement of it coming into force of this act, a legitimate method of enforcement. So getting damages for that, I'm afraid, is going to be quite a tough ask, in my opinion. If you then go down in the Q&A to another question which says, well, what if the petition isn't based on a statutory demand or an unsatisfied judgment, but simply on a section 123 demand letter that says we don't think that you're able to pay your debts as they fall due? Schedule 10 deals with that. I'm afraid the exceptions, the two exceptions, do still very much apply there. So there's no escaping it by not going after a statutory demand first. There's then a question about whether the Act applies to a winding up petition already issued in May, but based on a statutory demand which was served back in February and the hearing's not listed until July. The question is what happens there and what's the best approach? I'm afraid it does still apply. You will have seen that there was a provision within the bill about petitions which are presented after 27th of April, and so the court will still have to consider whether or not the exceptions do apply. The next question can be dealt with very quickly. It says, are the new rules going to affect the existing bankruptcy procedures? Not on the basis of this bill. This is just to do with corporate insolvency. There's a second to last question on the list here. The understanding of some people is that the relevant period regarding winding up petitions may be extended by regulation for a further 6 months. Does that remain in the draft bill? The answer is yes, it does. It's within that same suite of powers for the Secretary of State to make regulations all the way up until April 21. It may be that is likely to be the most effective and flexible way for the government to be able to manage whatever happens over the next few months, because much like virtually every other aspect of this crisis, we are sort of having to make it up as we go along. And the final question was an interesting one, is whether or not we think that the assumption for wrongful trading will be interpreted as a rebuttable presumption. I think it rather depends on which judge you get. Some of them are a bit more black letter and will say if it meant to be rebuttable, it would have said. In my view, it would be very difficult, given the rationale behind the scheme, to leave it as a non-rebuttable presumption. The whole point of this scheme is to try and help out honest directors doing their best to rescue their business and keep it running in extraordinary circumstances. It's not there to protect people who are going to take advantage of the scenario to get up to whatever shenanigans they want for 3 months scot-free. And I think looking at it overall, judges are going to be very, very unhappy if there's not the method to be able to rebut that presumption in the clearest cases. So I hope that answers that.
Yeah, thanks, Ali. That's great. That's a wonderful set of questions covering the whole range of things that we've talked about, and I think it demonstrates that this bill's really provoking some interest amongst the profession. Big health warning. Of course, this is a bill at the moment. It's got a number of stages still to go. Amendments might be made as we go through, and various changes might be made. So we'll have to have a look at the Act as and when it becomes so, and assess what the, if any, changes might be. But we'll see how it makes its way through the House. I think another question's just popped up. Ali, that's one for you. I think this is the last question then, and then we'll sign off for today. Ali, do you want to take that last question?
I think I will. Well, it's come from Stephen, and I think given that we've massively overrun our time limit, Stephen, if it's okay, I'll email you about this later on this morning.
Okay, that's great. So thanks very much for your attention today. I hope you've enjoyed the presentation. If you do have any feedback, then please do let us know. Send by email directly to myself, to Ali, or to any of our clerks. And hope you're all staying safe, and see you soon. Goodbye.
Thank you very much.